We're going to have two people speak. Muna and Ndulo, the third person on the panel, gave the keynote. Muna will come up, and after Mr. Chuck and Ms. Silbert speak, Professor Ndulo will give him a chance to comment, add anything he would like, and then I think then we'll get questions. So Evan Chuck, who read about him in the materials, partner in Brian Cave, managing partner of the Shanghai office. He's a graduate of George Washington Law School.
Thank you, Simson. I want to thank all the team at Mercer and the great program you guys put on. Thank you again. Evan Chuck, I'm a partner at Brian Cave and also the practice group leader for the International Trade Group. What I wanted to do today was I realized we are at the end of the day at a law school. I know some of you are thinking about topics for papers, and so what I'm going to do today is leave you with some roadmaps and also with maybe some topic ideas from a practice perspective, particularly focusing on international trade in Asia and also my focus, which is China. And so if you have any questions, feel free to raise your hands after we're really glad to talk to you. The kind of areas I want to focus on are kind of what I call sort of hot topic areas. Sort of transactions involving China. I'm going to talk a little bit about where the investment trends are in M&A. We'll talk a little about healthcare, pharmaceuticals, the outbound trend for Chinese investment in mining, natural resources, because that's important to them. I'm going to touch a little bit on anti-corruption and FCPA, where one of our colleagues talked about a little bit further, but give you a practical approach to the real challenges involving FCPA and anti-corruption in China. I want to talk a little bit further about export controls in China, particularly as in this global world we're seeing Chinese investment into U.S. companies that have technology and things that are going back to China. And then also, for those of you who are focused in e-commerce, I want to touch upon a little bit of things about data privacy and how that's going to impact some of the things you might be seeing. A little bit about my practice that might help too. I basically bring brands to Asia. So if you think about things like companies like Neiman Marcus, they're doing e-commerce things in China. One of my clients is a big video game company called Take-Two Interactive. They made about $1 billion about 3 weeks ago with a big game called Grand Theft Auto. They have about 800 video game developers in China. So they're very interested in trying to exploit the Chinese market. Essentially, if you think about factories, people have long supply chains. That's the kind of clients that we work with. It's a fascinating area, and we see that as something that's going to continue. And then increasingly, we're seeing companies coming back this way. So some of the clients that we're seeing are in the solar panel business. We have a client that is taking and investing into places like Southern California, using these EB5 programs, and then what they're doing is they're selling their solar panels into the U.S., putting them into places that have very high electricity costs, and taking advantage of these visa programs. First thing is I've got a slide that really helps you think about, we talked about a lot of different things. We talked about export controls, we talked about, I think we're going to talk about arbitration, litigation a little bit later. We talked about IP, we talked about customs. From a transactional lawyer's point of view, this is how it all fits together. When a client comes to you and goes, hey, I'm going to go to China, I'm going to go to Asia. What do? How do you put it all in order? This slide is going to help you think about the planning. How do you form the right entity? What happens when you get there? The operational issues? What happens when things go wrong? And then, typical lawyers, we're already thinking about the divorce and the exit before we get started. And so oftentimes, a lot of people come to me and they go, I'm thinking about going there. So what some of the most important things to think about actually is your tax planning. What does it mean? And there's this whole area of international tax that you may have touched on here in school, but it's something that's very, very important. So I would say if I had to do law school all over again, I'd probably take 3 or 4 more tax classes. So that's something I would definitely talk about. We talked a little bit about the spaghetti bowl of trade regulation and trade agreements. That's over here. This is this whole, where can I get optimal treatment between countries with respect to basically the tax treatment for both sides. How do I get my both tax and non-tax benefits with respect to trading goods? Trading goods, that's where that comes in. Then there's also this whole issue of, you'll hear about joint ventures, contracts. Where does that come into play? That's usually in the formation. When you deal with places like China, sometimes you have to remember, everything you've learned in contracts in school, you go to a place like China, flip it on its head. Because literally, in school, if you look at the Georgia code, right, you want to ask yourself, what can I do in Georgia? I can do basically all things legal. I'm going to show you in a second. If you go to a place like China, you can only do things that are specifically approved by the government. Okay? So if you have a dynamic business model, guess what? Everything has a little piece of paper that you can have to chase. So that's really important. And then the issues that we touched on earlier, customs, export controls, S&P, all that stuff is when you get on the ground, what we do. We'll talk about that. So what drives the business that we're seeing today? Just out of curiosity, how many people know what's the biggest city on the planet today? Any guesses?
Beijing.
Nanjing?
Was it?
Nanjing?
Nope.
Mexico City.
No, Mexico City.
Mumbai.
Nope. It's a city called Chongqing. Okay? And guess how many people are there?
22 million?
32 million.
What?
Okay. You know how many people there are? Let's think about it this way. How many cities are there in the United States that have populations of 1 million people and above in the U.S.? Just guess.
10, 12,
20.
A little bit higher. Well, it's about 15. Okay. Guess how many there are in China? 160.
Oh.
That's what a lot of your companies, your clients are chasing. Okay. The other thing we're chasing is, we talked about Obamacare, right? China has $134 billion healthcare stimulus. Because if you're in the big cities, people are over-medicated because the Chinese doctors don't get paid very much. But they do get paid when they push drugs. If you're in the countryside, they don't get paid anything. So the country is trying to harmonize things. So what a lot of foreign companies are doing is, if you're a company like Cerner in Kansas City or Siemens, if you have a way of basically, if you're in Shanghai and you get sick and you're from Beijing, there's no way your medical records can get transferred. You're really out of luck. So there's technology that we have, GEs, all those companies are going to China to basically take advantage of money that the government has set aside to basically allow for development of those kind of technologies. There's also medical devices. But that's one of the things that they're pushing. The other thing that we're seeing is what we call the great outbound investment policy. This is China trying to continue to fuel its expansion. So China has its policy of going to various geographic parts like South America, like Africa, to secure its natural resources. Now, these are things that sometimes if we're sitting here in the United States, we're not really focused on because we're kind of US-centric. But if you think about it, and I've done some of these deals, there are interesting transactions going on involving Chinese labor, Singaporean technology, Islamic financing to build cities in places like the UAE, facilities, refineries in Africa. And the governing law of these transactions will be Hong Kong or UK or even French. These are the international cross-border transactions that go on. And there sometimes is absolutely no role for the US. But it's something to keep in mind because that's what's happening. One of our previous speakers talked about, is China a middle-class trap? Okay. One of the arguments where it might be is because one of the points I mentioned before is that China's legal regime is exactly the opposite of the US, in that it's not one where you can do all things that you can that's legal. It's really defined and hampered by what the government says you can do. And it's only increasingly getting regulated. So what that means is, if you go to China and you want to do a business, everything basically is being increasingly regulated from the financial perspective, from real estate to basically every regulatory agency. And so oftentimes what that also means is you may have, if you think about it in the United States, if you go to a US agency, we have something called the Administrative Procedures Act, right? And so if we have a standard that says governments can't be arbitrary and capricious, in China, you don't have that. So essentially, the agencies in China will have a very, very broadly defined statute. Then it'll have something that's an implementing regulation that may define that a little bit further. And then the agency has huge discretion, basically, to then interpret those two items. And then you're left to basically say, well, government, what do you, this is how you interpreted that. I don't have any other recourse. And so oftentimes what that means is if the government decides against you, you're really out of luck. And again, from the FCPA perspective, that's oftentimes where the rubber hits the road, because you've spent a lot of investment, time, and effort to try to get a project going. The government rules against you. You don't have real recourse, and people get put in a very difficult position. What do you do? And so that happens a lot of times. Another issue that I think one of our previous speakers talked about was domestic innovation. So how does China get more technology? They actually have a new policy in place that it's very vague again, but essentially what they're saying is if you have a technology that is innovative and you locate your facility close to one of its, say, military facilities or one of its special technology zones, you have to give your technology over to them, or you have to have it considered by a review board in Beijing. So that's something that you should look for as well. I'm going to skip through some of these there's other new regulatory restrictions that are being imposed on investment as well. Most importantly to look at is several years ago, people were saying that you go to China because the labor and employment situation is such that you have cheap labor. Since 2008, China's moved to a European-style labor code, so that in some cases, if you renew a Chinese labor employment contract 3 times, you essentially have an employee for life. Very difficult to terminate them. So it's actually gotten much more expensive to have a Chinese employee. Also, for those like me who work in China, China just said last year, congratulations, you're now paying Chinese Social Security tax. Not like I'm going to retire there, but it's several $1,000s a month. So that's it. For those of you who are interested in employee benefits, oftentimes it's getting very competitive to basically hire Chinese nationals and keep them. And so people will say, I want to give them stock grants, or I want to give them stock incentive plans. Those are very, very difficult to structure in China. And it's an area that's evolving, so it's also a good area for topics, for papers, because China doesn't allow people to move money back and forth freely. There's foreign exchange controls. It's something to watch. Probably the biggest development over the past month, in fact, is Shanghai announced that it's planning on allowing the development of something called the Shanghai Free Trade Zone, essentially another new Hong Kong that's going to be sitting in the sort of Pudong area of Shanghai. As again, with lots of things in China, it's a big edict. The details the devils are in the details, and they're trying to sort of marshal and get the banks to sort of buy in. If it does happen, it's going to be huge, because literally they're going to drop a lot of the trade barriers that are going to be there. So that's something to watch. If you're interested in writing a paper on that, I would look at that. If you're thinking about the basic keys to China's legal system, I would focus on the following. It's a civil law system. That means there's no stare decisis. Just remember, if it's not approved, it's illegal. From a court system, there's no injunctive relief. So a lot of our thick contracts that we have in China, in the US, we try to translate into China, it won't work because it doesn't mean anything. If you get a legal opinion from a Chinese law firm to you, look for the fine print, because you'll get the fine print from a Chinese law firm that'll say, we can never be certain that the laws of the PRC will ever be enforced the way it's written. So you will just pay $12,000 for an opinion that's not worth anything. So watch that clause. A lot of the structures that you'll see are not tested. And as my colleague here is going to talk a little bit about, disputes are increasingly being resolved by arbitration in places like Hong Kong and also Singapore. And there's a reason for that. China will not recognize automatically foreign judgments. It will honor foreign arbitral awards. Enforcement's still problematic, and again, we'll have another colleague who will talk about that. If you're looking for successful examples, I point to you Amway, Estee Lauder, both of which actually are clients. But Amway has really grown its business, and this is all public. You can read about them more in the press. I think Amway in China alone now accounts for several $billion in annual revenue, but they've had to adjust their model. They're a multi-level marketing company, but in China, there's no freedom of speech, freedom of association. So you can't have Tupperware parties in China. So we actually had to help them figure out how to do their business, and the solution was actually to have Amway stores. So in China, there's like 150 Amway retail stores. Estee Lauder for years, because of the counterfeiting problem, actually didn't even sell in China. They just had their brand name sort of generating publicity there. On FCPA, the big issue with China is that so much of the business is either state-owned. You can't tell what's a state-owned enterprise or what's not. Also, there is an enormous culture of gift giving. And so basically, you may have heard of things called red envelopes. We just had something called the Fall-Autumn Festival where red envelopes were given. These are also mooncakes. Sometimes we call them mooncakes with benefits. And there's actually red envelopes that are given underneath. If you're selling like a healthcare business, you have to sell your goods to doctors. Doctors are oftentimes state government officials. Lastly, in terms of export controls, you have a lot of Chinese people who are buying technology companies in the U.S. Sometimes you'll get these Chinese owners that'll go, why do I have to comply with U.S. export control rules? The hardware is made in China, but the software comes to the U.S., gets changed and then sent back to China. As Lynn was saying before, that information, that software is controlled. And we've had situations before where the Chinese owners get in major trouble. Lastly, in terms of data privacy, in the US, if you try to build a profile for games for 16-year-olds who play these video games, right, so all kinds of restrictions. In Asia, at least in China right now, there isn't. So there's actually an opportunity for retailers. But that's changing because there's all kinds of developments that are going on in Asia, and we should watch out for those. But it's an interesting development for people that are interested in e-commerce. Anyway, that ends my presentation. Thank you.
Thank you. The next speaker, Elizabeth Silbert, is an associate in Houston's office of King and Spalding. She's a Northwestern law grad. Thank you.
Thank you. When I was invited to speak at this conference on international trade, and they put me in a panel called Transactional Issues for the International Trade Lawyer, I was a bit nervous because I am neither a trade lawyer nor a transactional lawyer. I practice in international arbitration. I'm in King and Spalding's arbitration group. And as Professor Ndulo was referencing earlier, I do about 50% of my work on arbitrations arising under investment treaties and about 50% that arise under purely commercial contracts. So when I was thinking about a topic that would interest transactional lawyers, law students, I decided I touched on the practical aspect of how to draft proper arbitration clauses. It's something that is extremely important, and I think, as a lot of transactional lawyers will acknowledge, it often comes up as one of the last provisions that's negotiated. Everyone has rose-colored glasses at the beginning of a transaction and is very excited about this new relationship, and no one wants to think about all of the things that can go wrong. And because of that, I think a lot of times arbitration clauses are inserted in at the very end, everyone glosses over them and assumes that we'll have no problems. And there are forms that someone found online or took from the last transaction, and they're inserted again. That leads to a lot of problems. We end up, as an arbitration lawyer, rarely am I brought in at the beginning of the process to say, hey, will you look at this arbitration clause and tell me the red flags. Instead, we get a signed contract that was signed in 1985, and now there's a problem, and the arbitration clause is 5 pages long, and it contradicts itself, and it's a mess. So I would encourage everyone to, when they're thinking about arbitration, the arbitration does not begin when you file the dispute. It begins when you sign the arbitration agreement. You have a lot of autonomy in deciding how exactly you want to conduct your arbitration. It's one of the great benefits of arbitration, as I think a lot of people will tell you. You can choose your procedures, how long it will all take, and one of the favorite things people really like about arbitration is you get to choose your decision maker. And in most cases, you have a 3-part panel, so one side will pick theirs, the other party will pick theirs, and those two will pick a chairperson. And different institutions have appointments in different ways, but this is obviously an enormous advantage, especially if you are engaged in a very technical business or something like the construction industry, where you want an industry expert deciding your case. You don't want to roll the dice with a judge who last heard a construction case 10 years ago. And so this is, it's an efficient way to do business. When it works out well, it works out beautifully. There's a lot of focus on the problems with arbitration, and there are some, but I want everyone to encourage everyone to think about a lot of the advantages it brings. The other one that Professor Ndulo touched on during lunch is this portability of arbitral awards around the world. The New York Convention, with more than 180 signatories, as he mentioned, is an enormous advantage when you have an arbitral award that in 180 different countries you can take it to a court and they immediately will recognize it as a judgment. There are a few very limited bases that you can turn over or refuse to enforce an arbitral award, but they're for things like fraud, bias, manifest disregard of the law. It's really going to be a high hurdle. And that's an enormous advantage if you need to move quickly against someone who owes you a lot of money. A few things I really just want to touch on, a few red flags to consider when you're contemplating an arbitration clause, deciding whether you want to agree to arbitration, and if so, how do you want it to go forward. Probably, as I mentioned, the most important thing to think about is your panel. Who's going to be deciding your case? This depends on your selected arbitral institution. The AAA uses a list method. They have this large sort of chartered institute of arbitrators, a long list of people to choose from. Either they will pick or you can pick. Some people have real problems with this list method, however, because it may exclude people that you really like, or you might really not like the list that the AAA has given you. The London Court of International Arbitration, which is very well respected, actually appoints the arbitrators for you. That scares some people because, again, I think party autonomy and being able to pick your own arbitrator is very appealing. But the LCIA has a very short list of arbitrators, and they're pretty much universally very well regarded. These are like the cream of the crop people. So if you are thinking about a UK law contract, the LCIA has a list of the best, barristers in the world, and that might be a good option for you. Another way to do it, obviously, is to specify a selection process yourself in the contract. As I mentioned, you may want 3 arbitrators for a complex dispute so that you can make sure both sides get their say. If you are dealing with a very small contract or something that you want to move very quickly, you might consider a sole arbitrator. That will save you a lot of time. Obviously, it'll save you a lot of money. It's 1/3 the arbitrator fees, and you're not calendaring 3 different arbitrator schedules who are often quite busy. And so it's something to certainly think about. Another thing is whether you want to have an expert arbitrator or have an expert requirement for your panel. As I mentioned, things like construction disputes. When you have a dispute over construction delays, you have world-renowned experts on construction scheduling. This is not an area that I think you would want a novice deciding for you. So consider that if you're doing a very complex construction project. And you can incorporate into your contract a requirement that, for example, in a construction case, you want an engineer. You want someone who has that background, who understands the language, and is not going to be getting up to speed while he's deciding your case, or she. The other thing you want to do when you're at the point where you're in a dispute and you're selecting your arbitrator, I think one thing that a lot of people overlook is the arbitrator's background and their legal training. If you are in a contract that is set in a civil law system, so for instance, if you are doing a contract that is based in Spanish law with a Spanish party, you might very heavily consider picking a Spanish arbitrator, or someone at least who's trained in civil law that's going to understand that system of law. This may not be the best case for you to pick a U.S. lawyer or a barrister. It may be a situation where you really do need a civil lawyer. And something I was talking about with Evan earlier, language is something that you also really should not overlook in these contracts. I understand a lot of us that do international law, things are done in English, and many times contracts are written in English, it's the controlling language, and if so, that's fine, but sometimes they're not. And if your contract, if the original contract is in Spanish, and everyone who negotiated that contract is a native Spanish speaker, you may not want to conduct your arbitration in English. You may not want to pick an English-speaking arbitrator, especially if you consider that if your arbitrator is a Spanish native, the other two arbitrators may not be, and then all of a sudden your arbitrator, your selected arbitrator, is the expert on some of these language issues, on some of the legal issues. And these are certainly things to consider, and I think sometimes things that are overlooked, people think it's simplistic, and well, a lot of these people are bilingual and it's no problem. But really when you're getting down to very specific language issues and contracts, every arbitration I've ever been in that involves a non-English language, there's a huge fight over translations of one word. And so it is very important not to overlook the importance of language. Especially, again, with something like Mandarin. Again, Evan and I were talking earlier, there are some Chinese words that just truly do not translate into English and vice versa. And consider if it's that important, if the language of the contract is the basis of your whole case, you probably want a native Chinese speaker. As your arbitrator, you don't want to be having to convince someone that you have the right translation. In terms of the chairperson, a lot of times people have questions about that. It's most typical that the two party appointed arbitrators will select the chair, and people will ask what is their role. If you have any say in the chair, which sometimes you don't, they really are the presiding officer, and they're responsible really for the administration and pushing the case along. Different arbitrators have very different reputations for how efficient or inefficient they are. Some of them are terribly inefficient, and arbitrations languish for years because the chairperson is very busy or just is not very timely, and so deadlines just lapse, whereas others are extremely fast and you get your award quickly, and that's also very important. In terms of the scope of arbitration, when you hear about most arbitration clauses, you would think you normally hear the narrow clauses. The parties agree to arbitrate all disputes arising under this contract. It's just sort of your basic contractual arbitration clause. But you have to remember that that does not include statutory claims or torts or certain other claims that could come up. That's sort of viewed as the narrow clause. The broader way to do it and the better way to do it in most views is to say you're going to arbitrate all disputes arising under or relating to this contract, and then you loop everything in. My general view is that arbitration clauses are better when they're broad. If you're going to arbitrate anything, I think really you should arbitrate it all. Trying to carve out claims that you may arbitrate. I want to arbitrate the contract claims, but not the tort claims. I want those in court. That you are just going to end up litigating and arbitrating at the same time. You're going to end up possibly with the possibility of contradicting judgments and awards, and it's just a mess. I really think unless there's a very good reason why you don't want to arbitrate everything, go ahead and put in a broad form clause. And if you're looking at your arbitration clause and it's 4 pages long, that's probably not good. Just think about, how do I simplify this? How do I make sure that I really am capturing what I want? And you don't need to reinvent the wheel and put the whole procedure in there. When you select your institution, whether it's the AAA, the LCIA I mentioned, the ICC, the International Chamber of Commerce, all of those places have the rules in place already. You don't have to restate them in your contract. One last sort of category that I want everyone to think about, and then I'll give my general takeaways, is to think about both the governing law and the seat of arbitration. This is something else that I see a lot of confusion with, and you end up with contracts that create major problems for companies that don't realize what the difference is between the governing law of the contract and the seat of arbitration. So the governing law, when you say this contract will be governed by California law, that is the substantive law that's going to be applied to your claims. So your breach of contract claims will be under California law. That's what's going to apply. Again, just remember when you're selecting an arbitrator, if that arbitrator is not a California lawyer, you're going to need to educate him or her about California law, consider whether or not that's something that you want to take on, or if you want to hire a California lawyer. The arbitrators will take evidence on the applicable law, so you do not need to have someone licensed in that jurisdiction to apply the law of another jurisdiction. But again, just consider how hard it's going to be for you to explain to, say, an Argentine lawyer who's a civil law trained lawyer, Australian common law, and how difficult that is going to be for him or her to reconcile with his own legal training. The second provision that you're going to have a legal selection in is the seat of the arbitration. And this usually comes up in the arbitration clause itself. So usually in these big contracts, there'll be a governing law section that's very short that says that California law applies. And then the seat of arbitration may well be somewhere else. So, for instance, you probably don't want to seat your arbitration in California. It has very strange arbitration laws. The courts have issued some very odd decisions recently, either nullifying awards, refusing to enforce them. So for instance, even if you wanted the law to be governed by, the contract to be governed by California law, you probably want your arbitration seated somewhere else, like New York, or Houston, or even Atlanta. New York's probably the most common because New York courts, Southern District of New York sees arbitration cases all the time, international arbitration cases on a regular basis. So you're looking at that and you think, gosh, I've got two different state laws applying, and obviously in the international context, this could be two different countries. What's the difference? The seat of the arbitration is the procedural law that governs the arbitration. So if you've chosen New York as the seat, New York law is not going to apply to your breach of contract claim, but it is going to apply when you seek to enforce the award. If you lose and you want to move to set aside the award, New York's where you're going to have to do it. And also there are some other procedural issues that can come up during the course of an arbitration where you need the court's help. You may need to get a motion to compel the other side to even participate in the arbitration. Sometimes they will, put the head in the sand like an ostrich and then not respond to your arbitration demand. You may need to get the New York courts involved. So just remember that. In terms of, people think of the seat of arbitration is where you have to have the hearings, and it's not. The parties can choose somewhere more convenient. Obviously, if one party is in Singapore and the other party is in New York, just because you've seated it in Singapore doesn't mean you've got to travel over there. You guys can meet in London. That's also sometimes a misconception. You don't physically have to go to that place. In terms of resources, just in general, when you're thinking about arbitration clauses, look at the major arbitration institutions. They have some good form clauses that are a good basis, but I would not insert them wholesale. I'd look at them, sort of see what they have to offer. And when I say the arbitration institutions, I mean AAA. The ICDR is the international wing of the AAA, which has a very good set of rules. LCIA, ICC, in terms of the treaty institutions, we have ICSID, UNCITRAL rules, Stockholm Chamber of Commerce. So feel free to take a look at all of those websites. Are excellent resources. And next time you are law students and practicing lawyers and you are drafting a major international contract, please don't leave the arbitration clause for 11 p.m. the night before you sign. Think about it, and you'll be grateful when the dispute does arise. So thank you all very much.
So I wanted to invite Professor Ndulo, who's our keynote speaker, if you'd like to add any, either commenting on the two speakers we heard or adding, even if you want to add back in in some of what you said in the keynote, is not everyone there.
No, I think I just really agree with what my colleagues here say with respect to the speaker, the emphasis on the risks and the importance of understanding the legal system of the place where you are working. And I agree 100% with what Sibert has been explaining. I mean, the choice of law clause is very important because that's going to govern the substance of the dispute. And also the enforcement, as you pointed out, the New York Convention. Also, really, many lawyers who operate in the domestic environment actually think judgments are easier to enforce, but that's not true. Arbitral awards are 100 times much easier to enforce than a judgment. Very difficult, unless there's a bilateral agreement between two countries. You're stuck with just your country when you have a judgment. So it's really very, very important that, of course, when you are arbitrating, you have to make sure that the country you are arbitrating in is party to the New York Convention, because that will mean that you can enforce a judgment anywhere. And I think also the choice of the chair is very important, because the two arbitrators are chosen by either side, and the neutral guy is supposed to be this. Well, all of them are supposed to be neutral, but at least he is or she is not chosen by the companies involved, and I think plays a very critical role in terms of pushing the process forward and all that. Yeah, and UCITRA has, there's also people who want to arbitrate outside the system. I mean, the ad hoc people. Yeah, and UCITRA has ad hoc rules which you can use when you don't want to go to ICC, you don't want to go. But the problem with that is that you would have to almost structure everything yourself, including the administrative support. You have to appoint your own secretary, your own everything. Whereas with an institution, at least there's backing. It helps you to do that. Yeah. I think one other thing we didn't touch on in terms of the investment structure, I think, is the insurance system, MIGA. For research, for those who are doing research, it's a very, very important system that's in place called MIGA, which is the Multinational Investment Guarantee Agency. It's a huge insurance scheme that the US is a member of that. And most countries have their own domestic insurance schemes. So the Japanese have their own, the Americans have their own OPIC, the British have their own. But those are usually geared, well, one of the qualifications that the national, generally, it can be a little liberal, but one can say that they're geared to ensuring their own nationals. The deal with the MIGA is that it insures everybody, as long as the countries are members. So the other thing is that, of course, you have to be investing in a country which is party to the convention. But otherwise, you find that a lot of US corporations are actually insured under MIGA when they go to invest in a developing country. Because that way, when you are nationalized, something happens to you, you just put in a claim, and MIGA subrogates, takes over the claim for you, and you forget about it, and they deal with the country themselves. And of course, MIGA has a high level of success in terms of compliance because it's backed by IMF and World Bank. The country wouldn't dare to disobey those institutions because it has implications for its own trade, in terms of financing internationally, you'll be blacklisted. So it's a very, very important scheme, that's all. But also sometimes MIGA co-insures with the OPIC. They can work together, they can insure a percentage and in very big schemes. So that's another area that I think those that are interested in international trade could look at. It's a huge program. I think I will end there and then participate in the question and answer session. Yeah.
Just to take, since we're maybe just a counterpoint to the arbitration case, it's just as an example of where sometimes arbitration can go the other way. Just as a young associate, I worked on behalf of the U.S. lumber industry, and sort of an arbitration type of situation. The U.S. and Canada was in a very bitter dispute in the lumber wars. I represent the U.S. lumber industry against Canada. And under the U.S.-Canada Free Trade Agreement, we agreed with Canada to allow disputes in the trade world to go to these binational panels. And in this dispute, we accused Canada of illegally subsidizing its lumber industry. And it went to, it used to be that it would go to the Court of International Trade to essentially to litigate these cases. But under the U.S.-Canada Free Trade Agreement, it went to these binational panels. And you essentially, by lottery, you figured out how many panelists you have. And we had 3 panelists, 2 of which, actually 5 in the first panel. 3 were Canadian, 2 were U.S. And the U.S. lost. And we're like, okay. So then it went on to 3-2. Luckily draw, 2 Canadian, 1 U.S. We lost again. So as the junior associate, the partner I worked with said, why did we lose? Go figure that out. So I dug in. This is the first days of Lexis, right? So you spend hours and hours, and I was like, wow, one of the panelists, their law firm actually represented the Canadian lumber industry in front of the panel. And so we pushed and pushed and pushed. And finally they said, oh, well, we're Canada. We don't have as many lawyers as you guys do. So we don't have that conflict problem. And it actually ended up at the congressional level with Senator Dole raising that. And it almost blew up in NAFTA. So I'm just saying that sometimes that's an extreme example. But your point about checking out the arbitrator can be an efficient point.
And you can challenge arbitrators. So if you do find something like that, due diligence on the other side's arbitrator and find out there's an obvious conflict, you can raise a challenge and have them disqualified.
And in today's sort of modern deals, like in China, the point that we talked about is very, very important. If you can get English, get it. But if you're in places like in China, the language is really important because the point that I talked about is Chinese is very difficult sometimes to distinguish things like shoulda, woulda, and coulda. And so, should you have taken precautions so that the explosion didn't happen? Should you have? Those kinds of things are very, very important. So you want to be careful of those things.
Questions from the audience, and if you have a specific person you want to direct it to, why don't you?
Yes, for both of you, I get dialect, not just language, but Spanish. It's different from a number of different versions, Mexican, Costa Rica. So wouldn't you have to take that into account as well?
Sure, yeah. I think some of that has to do with, I think it's a little different when you have a very formal legal contract. I mean, I had one experience where we were dealing with the translation of the word principales, meaning that we wanted that to mean the parent company. But actually, the typical Spanish word for that is matriz. So we had several people come to us and say, oh, principales, it's principal, it doesn't mean parent company. But in that country, it did. So that was one where, it does make a difference that really a local lawyer, we had an expert come, corporate lawyer from that country, which is the South American country, come and say, I know in Spain they would say matriz, but here, principales is normal, that's legal, what we would use in the legal community. So it does, it does come up.
For Elizabeth, there's a big push in Georgia now to establish Atlanta as a center of international arbitration. I wonder if that's come to your attention. And also, would you talk about choosing venue considerations?
Yeah, I'm aware of the group Atlas, which I'm sure
Atlas,
you all
that's
know.
the one.
Doing great things, and obviously I think one of the big things that can be done is improving the Arbitration Act here, which I think is well underway, and having facilities, which I think Atlanta does. The airport is huge. Honestly, having that here makes an enormous difference. and having good courts, which Georgia does. So all of those, I think, set up to make Atlanta very appealing. In terms of choosing venue, you want to be looking for places that have a robust arbitration law in place. So usually in the U.S., the FAA will apply, the Federal Arbitration Act will apply, but there are some wrinkles to that. In most international arbitration cases, it automatically will apply, but in a place like Massachusetts, that actually was a very recent development. But before then, even international cases went forward under the Massachusetts Arbitration Act under a weird view they had of the Commerce Clause. So you're usually pretty safe in the U.S. that you'll have an FAA jurisdiction, but you want to know the courts. I mean, you want to know that those courts have seen an arbitration case before, that this isn't their first time thinking, oh gosh, I don't know about this private court system, and I know these factors for set aside are very narrow, but this feels fishy to me, and they might annul an award that in New York or DC would be quickly affirmed. So you do want to think a little bit about places that see a good amount of arbitration. In terms of worldwide, the very common kind of considered arbitration-friendly jurisdictions are in the UK, Switzerland, the Netherlands. Now Singapore is really emerging, Hong Kong as well for Asian markets. Paris a bit, although there's some quirks in French law. And so those are sort of the ones that you tend to see again and again. They have the institutions there. There are a few places that you want to avoid. I mean, I frankly think California is one of them, and they're trying very hard actually to fix two problems, which is they have one problem with some of the recent case law that's come out, and I think that there's been an uproar because people in San Francisco and LA think, my God, this should be a fabulous arbitration center, and it's not. So they're trying to fix that. And the second thing is there's a very weird quirk in the California bar that you cannot practice before an arbitral tribunal if you are not California licensed, and you cannot be an arbitrator seated in California if you're not California licensed. And they have sort of suspended that rule for a time being, trying to attract more arbitration, but everyone is it really scares everyone. I mean, an arbitrator is thinking, I understand it's suspended, but if it's repealed next year, then my award is now useless. So I think until that bar rule changes, California should be a fabulous place because, again, it's right, you could attract a lot of Asian arbitration as well, but they need to fix that.
I mean, as a California, one of the issues is, even just from a constitutional standpoint, we have a public policy exception for contracts. So, and we have also somebody called Chief Judge Rose Bird in the jurisprudence that causes some heartache in interpretation. But as an international lawyer, I think one thing we generally do, and I would recommend this to you, if you're asked to help negotiate a cross-border transaction, what we typically, in China, oftentimes the Chinese have been more emboldened to say, you've got to do Chinese law. And there's certain cases where you have to use Chinese law. For example, Chinese labor and employment situation, you're going to have to use Chinese law. But outside of that, what we generally try to do is we recommend norms like New York law or Hong Kong law. And then we would go with Hong Kong arbitration, maybe Singapore arbitration, and then by default there's something called CIETAC, C-I-E-T-A-C, which is Chinese arbitration. As I talked about this before, it's developing, it's not as great, but there's a strategy that you can employ with respect to what choice of law you want to take, and then what venue and sort of how you want to deal with it from an arbitration point of view. But they're very important. As don't wait until the last minute.
Yeah.
One additional thing on the clause, I think sometimes it's also useful to include international law.
Yeah, sure.
Yeah, because otherwise you are subject to domestic law completely. And a very good clause says that law plus
General principles of law.
General principles of law. Because especially if in the areas like nationalization, for example, then you get protection of international norms which set very high standards in terms of the norms say there must be compensation from all that stuff. So it's very important that you include that, of course, in there. Yeah. And I think that the courts, as you rightly pointed out, most people won't choose a place for arbitration if the courts have a reputation of interfering. They just avoid that place. They want where courts don't interfere.
John?
Now, I have a question about law and then about tribunals. In nations, you sort of anticipated my first question about laws. Are there other nations besides the United States where there are either provincial or state arbitration laws that one has to be concerned about? That's sort of disappearing as a result of the application of the Federal Arbitration Act. But it's still true that you have to worry about, and there are still, issues under state law. Are there any other nations like that, or are you pretty much looking at national or the nation's arbitration laws if you set the applicable law and stuff like that out in arbitration?
From a trade perspective, again, the NAFTA, and sort of its predecessor, the CFTA, essentially usurp the jurisdiction for international trade for certain trade matters into these sort of panels. And so again, and there's actually some, look at the sort of legal jurisprudence, there's dispute over whether or not it's constitutional from the standpoint of taking things that should have been under sort of Article 3 judges under their mandate and putting them in these sort of panels that aren't. But that's kind of from an international trade perspective one thing to look at.
All the other major arbitration acts that I can think of are all national. So I cannot think of another example that has a federalist system like this, that you've got provincial concerns. I'm thinking that most of the big arbitration acts that I can think of are all national arbitration legislation.
And the second question has to do with tribunal systems. Are there private tribunal systems like the AAA in other nations, or are they pretty much looking at, when you're doing trade issues, at international tribunals?
There are a couple, as I mentioned, CTAC, which is a Chinese institution. There's the Singapore International Arbitration Center. But these are all, and actually the AAA's international wing, ICDR, sort of strives to be an international center in the sense that it's not just seeking to attract domestic American arbitrations or even American parties. And so I think most of the other ones that you'll see they may be sort of regional in terms of the parties they tend to attract. The ICC and the LCIA in Europe, you'll see European parties use a lot. Whereas ICDR, obviously, usually there'll be an American party involved, and CAC, usually an Asian party involved. But I can't think of another one that is just a purely, like national institution that also does the international work.
John?
To what extent at all, I imagine, to some extent, you've encountered countries that want to apply Islamic law. Are you seeing that increasingly?
I certainly have seen that. It's a major consideration. It's come up a good amount today, but if you are looking to go into business with a Saudi Arabia or a country that has a very different and very rigid system of law that is quite different from at least the one in the U.S., that is one of many considerations. There are ways to do it, and there are ways that there's a huge practice of law in my firm doing Sharia-compliant lending, Sharia-compliant contracts. So there are certainly ways to do it. In terms of receptiveness to arbitration, I honestly can't say that I have seen a lot of arbitration. I have not personally done a lot of arbitration in the Middle East, but Dubai has a center, and so it's growing now.
One of the projects we worked on was a 99-story building in Riyadh, and essentially the financing for that was to be done through what they call a sukuk. It was a Malaysian bond financing that was done essentially without interest under Malaysian Islamic principle with Chinese labor, Malaysian Singapore financing with a Saudi sponsor. Again, it's a crazy sort of structure, but essentially that's how that works. But the dispute resolution is basically it would be under Dubai.
Yeah, Dubai.
Dubai structure. That's how it is.
I have a question. You mentioned the barristers in the City of London, how there's a sort of preeminent list there. I know QC barristers who are really quite amazing as international commercial lawyers. They work for the LCIA, but also for some of the other specialized arbitral bodies. My question, I have two really. One goes to choice of law. I know, how much do you see in choice of law clauses? I think the specification tended to be, for a long time, either New York law or English law. And how is that sort of operating today, I would say. And the second question I have is, Qatar has now set up a new specialized court, basically a commercial court, that looks a lot like the London Commercial Court, which has been set up actually by some of the justices in the UK, some of the barristers have helped them set this up. It's kind of an interesting phenomenon that those who did a substantial practice before either the commercial court in London or who have spent a lot of time in arbitration in London are now setting up this court in Qatar. Have you had any experience in the Qatar, this new court yet?
I can answer your first one with respect to English law. In China, the shipping area and the asset-backed, particularly aircraft financings, are almost, I would say, 70% English law deals, what I see English on the financing side. And that's, if there's a dispute, it's going to be, usually in the UK or Hong Kong. That's just because it's the norm. And it's so well established, particularly aircraft leasing agreements, and loan, lease sale-back agreements. We just recently did a deal involving a fleet of high-speed ferry ships that are taking thousands of tourists from Hong Kong to Macau, because Macau is now the Las Vegas of Asia. And so a fleet of ferry ships were all done in English law. And so, but with respect to your second question, I haven't had that experience.
I don't have any experience with the Qatar commercial courts either, but that's very interesting. I'd like to see where that goes, because it is, the London commercial court's a unique thing. In terms of choice of law, I agree. I see English law all the time. I think English law sometimes is a compromise with people who are contracting with American parties that don't want U.S. law. And so they'll say, well, we'll go to a common law system, but we want it to be European. So I do see that a lot, and I see a lot of French law, obviously with African countries that have a French law tradition. So I see a good bit of that.
But you have to be very, very careful. If we as Americans agree to English law, there are some really great tricks that those English lawyers stick us with. Things like best efforts, okay? If you ever have an English lawyer that says, I want you to do something with best efforts, in American terms, that means come hell or high water, which means you have to go bankrupt before your obligation is met. And they always love to stick that to us. So just remember that one.
Yeah, English law is very quirky. I mean, if you did not, you were not trained in it. Every time I have an English law case, I'm amazed by some principle that makes no sense to me.
In California, if you use best efforts, there's always the default back to reasonable best efforts. But I remember doing, again, in the aircraft or aviation finance world, return conditions on an aircraft. You never, ever put best efforts, because that would be like malpractice. So just again, you have to watch those, particularly in the finance area, because it's so well established in your English law practice.
Just kind of a follow-up. How far do you think your responsibility goes towards learning something about that foreign law that you may be inserting into your choice of law clause? You're not qualified to practice in the United Kingdom, or let's say you have a deal in Brazil. How do you can go to local counsel, but you're still not going to know all those nuances like best efforts with that local law. How do you advise?
Well, if an opinion, for example, is given, which obviously it is in these deals, I'm not the English lawyer that's giving that opinion.
Right.
But part of this is experience. I've done this for 20 years, so you do need to be able to navigate these things if you're being called on. And if in those kind of transactions, I'm being asked to apply and work on, obviously, the U.S. aspects of these things. But you do need to know, if you're part of the structure, certainly that there are these kind of traps that are in there.
And if you don't choose the law, most institutions are the default laws. So they will choose the law for you. I mean, it ends up the government law.
Yeah, well, that's the other interesting thing, when you're negotiating with a government, state-owned oil company in Indonesia, and they'll give you a 20-year production sharing agreement on a big block of land, but it's Indonesian law, take it or leave it. And so in that instance, I think it's especially important to do what Professor Ndulo said and say, okay, Indonesian law and general principles of law are going to apply to this contract, because otherwise, he's right, Indonesian law, they might write a new code tomorrow that says the state can impose a 99.9% tax on you, and that's Indonesian law now. And if you don't have any recourse to an international law system, then yeah, you're in trouble.
Yes, one thing I wanted to ask about, my familiarity is mainly as a conflict teacher with judgments and choice of law clauses in court systems. To what extent in arbitration is it sometimes not enforced? I mean, certainly there's room for that as a matter of, in courts, they'll enforce it in enormous proportion of the time, but there's certainly latitude to say we're not going to follow it under certain limited circumstances. How does that play out in arbitration?
Well, I was going to say, from a China perspective, China, by its agreement in the convention, it will technically recognize a foreign arbitral award. But enforcing the arbitral award in China can be very, very intriguing and challenging. And litigating something like that in China, as I was explaining before, I describe it to a lot of my colleagues, it's like litigating in 1930s Chicago. Because, ex parte communications are okay. And so people literally will call up their friend who they went to law school with, hey judge, you're in charge of all this, why don't you slip in this piece of paper? It's okay. And so there's this sort of home court advantage stuff that really is very, very problematic in that kind of place. And so you have to watch those kinds of issues in a place like China. And people sometimes don't really understand how challenging it can be. If you're in full-blown litigation in China, which we've been, there are situations I was describing earlier where we've had disputes where suddenly a third party will just mysteriously appear in the case, and you dig and realize the Chinese party set up a dummy South Korean company to basically interfere to cause your client to essentially spend hundreds of $1,000 to essentially clear this particular intervening party, and that's all okay. So there are those kinds of real practical on-the-ground issues that you have to face if you're in fact going to try to defend yourself in certainly litigation in China. If you go to sort of CTEC arbitration, there's a quality of the arbitrators and a quality of the jurists that can be really, really difficult to deal with.
I don't ever see an arbitrator disregarding a choice of law provision, because in the FAA and a lot of other set-aside legislation, there is a basis to overturn an award if the arbitrators exceeded their mandate. And very arguably, deciding a case under a different law than the parties agreed is an excessive mandate. So I'd be surprised. Everything is so contract-based in arbitration, I would just be, even if a judge would, for a public policy reason, strike down a choice of law clause, I don't see an arbitrator doing that. You agree?
Now, what's the sort of status of Hong Kong, in all of this with, it's now Chinese law, but it's really still sort of, British operated, and then if you're gonna, I guess if you have your arbitration there, it's just a place to meet, but if you seat the arbitration there, then it's, that's a different, how did...
From my perspective, Hong Kong actually is a great thing, continues to be a great thing, for a number of reasons. From a contracts point of view, a lot of these Chinese companies 10 years ago didn't have any exposure to Hong Kong, so you were really kind of out of luck. You had to go and enforce your contracts on mainland, which was really a problem. In the past 10 years, the great thing is they've all gone public in Hong Kong. So I always love it when they tell me, oh, I'm publicly traded in Hong Kong. I'm like, great, you can pledge stock to me in Hong Kong, right? Or I can build an escrow. There's all those measures I can do, so that's a good thing. I think the uncertainty theoretically, right, with Hong Kong law is it used to be that the sort of Supreme Court, shall we say, in Hong Kong was the Privy Council in London. So now that really is the Supreme, it's really in Beijing. You really go there, but that's the rare case. And so commercially, it's still really British common law in most cases. And I haven't really come across a lot of issues. Now, that said, there are still quirks of English law, that causes a lot of heartache. And they usually come in the areas of shareholder agreements. We have a lot of shareholder agreement disputes that the unwary U.S. American party that comes in and thinks, oh, well, for example, if I have shareholders that are having disputes, in the U.S., what do? We go into court, we get an injunction. In Hong Kong, it follows more the British model. There's usually these sort of cross powers of attorney that you have to have in place, and if you don't, you have to sue in the contract. There's these procedural things that Hong Kong law has taken, sort of based on English law, that it's kind of taken its own court, and if you're not familiar with Hong Kong law, there's these procedural traps. So it's kind of not PRC, not truly English law, truly Hong Kong law. And if you're not familiar with that, it can be really mind-numbing.
This may be a question for all of you, but maybe primarily Elizabeth has not. You mentioned traps, Elizabeth, you talked about all the traps. Can you estimate how frequently you think lawyers fall into those traps, or perhaps relatedly, how often you've seen that happen?
From my perspective, it's I think one of the questions you asked, how much do you need to know? And I think what I see is that practitioners who really don't do this often are the ones that tend to fall into those traps. I was telling Elizabeth, I have a client right now who is in a horrible position. It's a big publicly traded company, and they have a regular outside counsel that is a patent, basically based on more of a patent lawyer, not a cross-border lawyer, not a transactional lawyer. So this patent lawyer negotiated a very, very large distribution and licensing agreement with a Chinese company and forgot to put in an arbitration clause. And got into a big dispute, and then decided that they were going to spend upwards of $10 million in litigation fees to litigate federal court in the U.S. with the Chinese company. And as I said, so they spend all this money, they're going to probably duke it out, but they'll get to some judgment, and guess what? It's going to be worthless because they have to relitigate the whole thing in China. What's that malpractice? Question mark. So that's the kind of trap that, again, if you're doing international business and you really aren't sensitized to issues, you can really fall into a very, very bad situation quickly.
That was a failure to include an arbitration clause at all.
Absolutely. I think the person was probably thinking in their own world, this is not something I regularly deal with. If this was a set of facts that were dealing with international business, this would have been, 30 seconds. Somebody that does this all the time would put that in, and they could have saved this client probably $10 million.
I think part of the problem also is that, in a lot of law school curriculum, this is, international law isn't seen to be a big thing. And then, of course, in practice, you see that it has an impact. And I think it's also just like any other profession, just like a doctor. One who has done 100 operations is better than the guy who has done 10.
I think we all tend, when I was in law school 20 years ago, we tend to think very domestically. When I went to law school, I was fortunate to be in a program that had a very, very strong sort of international basis and sort of curriculum. So, but even back then, it was more just U.S. international trade. And so, again, the world's changed a lot in 20 years.
Yeah, I see a lot of bad clauses, either ones that have internal contradictions, or ones that have these crazy procedures where they think, oh, well, first we're going to go to a fast-track arbitration, and we'll do, within 6 months that'll get wrapped up, and then that can get challenged before a 3-person tribunal under unsubstantial rules, and so you just end up dragged. What I can see what they intended, which is that, we don't want to start World War II over every little dispute. But what it turns into is you've just prolonged the entire process another year. Obviously, the party who is being sued is going to take advantage of every little loophole, every opportunity to challenge, every slow up that they can. And so the more layers and procedures that you add, the longer it's going to take. And so that's why I advise to keep it very simple. I mean, these arbitration institutions have done this for decades. They know what they're doing. Just pick an institution, pick your governing law, pick your seat, and let it go. You don't have to reinvent the wheel.
I would commend one other thing too. For those of you who are either interested in corporate law or are corporate lawyers, one common mistake that I think some of our colleagues make is on these international trade issues, particularly export controls or FCPA, particularly in the heat of a merger acquisition, we kind of tend to relegate these sort of trade issues to a due diligence list. And it's kind of like the last minute they go, oh yeah, there's this like FCPA due diligence. Hey, why don't you just like deal with it, right? Okay, the thing about FCPA due diligence is you're proving a negative. You're proving that something doesn't exist. It's not like you can go get some Secretary of State certificate and go, no bribery happened. You gotta go ask the questions. And so there's always that problem. Lynn and I talk about export control compliance, right? Like how many times do you get the call of like, oh, we're closing next week. Can you just deal with it, Lynn?
And sometimes, in those situations, there are actually U.S. government notifications that need to go into place and things like that. So more than once, I've held up a deal because people have not thought about the issues and haven't done due diligence, and all of a sudden they either find a lot of problems or there are government notifications required and we can't meet the notification deadlines. So it's actually quite a problem in many situations.
I mean, in the FCPA world, particularly in places like China, it's the thing that people love to kick the can down the road. I mean, I've been in lots of deals where, just recently I was one company that's a target for an acquisition. They've been in China for 7 or 8 years. I started talking to them about, well, what's your FCPA compliance program like? We haven't had one until last month. And that was right before the deal started. And I'm like, okay, what was your compliance? What was your compliance plan like? Or what kind of problems have you had? Or what kind of interaction? Everything's been great. It's like right here is in China. Right. So those are kinds of practical things that you'll see, but it's and again, everybody realizes the sensitivity, but I always explain to clients, particularly in the FCP area, it's not about the bribe, it's about the accounting, because I think one of the earlier speakers were saying, you'll find if you're trying to think about trying to really prove a bribe happened overseas, right? Think about the standard, beyond a reasonable doubt. Are you really going to find the facts, the emails, all of that? You're going to find a lot of smoke. Where are they going to get you? They're going to get you in the accounting, because you're going to basically show the records and basically what is that record going to show? And in China, I don't think I brought one with me, but there's this thing called a FOPGAP, which is a receipt, and it's the bane of everybody's existence, because on this receipt, it's a Chinese receipt, you can't ever match up the restaurant, for example, with the name of the company that owns the restaurant. And it's like script, because people trade this little piece of paper. And that's where a lot of accounting fraud starts. But that's really what sometimes that's about. That oftentimes people want to keep this FCPA going on.
I want to thank the panelists. Jennifer, I just wanted to thank all the speakers and the organizers. Joel has done a tremendous job, Mark, with the law review. I think it's really been a terrific conference, and I've never seen such sophisticated questions from the audience, so I think it's terrific. Thank you.
I just want to say again, I just want to say again, on behalf of Robert and the entire law review, how grateful we are for Mr. Williams, Ryan Cave, the Stetson School of Business, and of course Dean Simson and Mercer Law School for co-sponsoring this event, and ICLA of Georgia. I also want to thank Professor Jones, of course, This has been an exciting and really more than we could have ever expected fantastic event, and we really appreciate all the presenters that have presented today and really given us a lot to think about and a lot of practical tips to go forward with, and very stimulating, I must say. And I want to thank the moderators that really challenged us and challenged the presenters, and particularly all of you for coming and asking fantastic questions, as Dean Simson mentioned, and really getting to the heart of the matter. So thank you again so much, and I also want to mention that the articles emerging from this symposium will be in the Mercer Law Review, Volume 65, Lead Articles Edition. Thank you so much, and it's my pleasure to adjourn the 2013 symposium. Thank you.